Authorities imposed a $3.2 million fine on Elon Musk, expecting him to simply pay and move on. However, his actions in the courtroom left even the judge in disbelief. It was supposed to be a routine morning in courtroom 7B of the federal courthouse in Fresno, California. A light rain tapped against the windows as the clerk shuffled through documents. Reporters sat at their designated table, adjusting cameras and sipping coffee from paper cups. Then the doors swung open, and Elon Musk entered alone, no security, no legal team, just a gray suit, a dark tie, and an unreadable expression. The room exchanged curious glances, but no one was particularly surprised. Musk had been summoned for allegedly breaching court protocol during a prior corporate hearing involving one of his companies. According to the court's complaint, he had disclosed confidential case details at a press event weeks earlier, a clear violation, or so it seemed. Presiding that morning was Judge Deirdre Colton, a sharp and precise figure known for her no-nonsense approach, especially with high-profile individuals. She glanced up from the bench, briefly locking eyes with Musk before returning to her notes. "Elon Musk," she began, her voice calm yet firm, "you have been found guilty of violating federal court orders regarding sealed testimony. The fine is $3.2 million, payable within 14 days. There was no surprise, no dramatic pause. After all, this was Elon Musk, billionaire, CEO, media magnate, a few million wouldn't faze him. Yet something about his demeanor, standing there with his hands loosely clasped, showing no reaction or objection, caused a subtle shift in the room's atmosphere. Judge Colton leaned forward slightly, perhaps anticipating a response. "Do you understand the terms of the ruling?" she asked. "Yes," Musk replied softly, "but I'd like to address the court." Heads turned, and several reporters sat up straighter in their seats. This man had arrived without a lawyer, and now he was requesting to speak on his own behalf before a federal judge. Judge Colton appeared skeptical. "Mr. Musk, I strongly advise you to consult with legal counsel before proceeding." "With respect, Your Honor," Musk said, "I believe it's more appropriate for me to handle this myself." She nodded slowly. "Proceed." That's when the atmosphere began to shift. Musk reached into the inner pocket of his jacket and pulled out a single sheet of paper, neatly folded, without a binder or folder. He placed it on the table before him. "I don't dispute what I said publicly," he began. "But I do question whether the gag order was applied in the context it was intended." Eyebrows raised, this was a legally gray area. He continued, "The order cited in the contempt filing pertains to Section 35B of the Protective Hearing Directive issued on March 11. However, under subsection 35BE3, public safety exemptions permit disclosure under federal fair use exceptions, particularly when the disclosed content relates to risks affecting shareholders." Judge Colton blinked once. Reporters began typing furiously. "I only mentioned one aspect of the production process," Musk explained, "which, if misinterpreted, could pose a danger to consumers. I didn't name individuals. I didn't quote protected documents. I referenced my own concerns based on what I witnessed firsthand." The courtroom fell silent. Behind him, a legal assistant leaned over to whisper to a colleague. Even the bailiff near the door looked slightly unsettled. Judge Colton raised an eyebrow. "Are you suggesting you're protected under federal whistleblower laws?" "I'm saying," Musk replied, "that the fine imposed on me may contradict the precedent set in Stanfield v. U.S. Tech Holdings, 9th Circuit, 2004, where the court ruled that disclosures serving the public interest cannot be penalized under sealed protections if the statements exceed the initial parameters of the gag order." Elon Musk had been summoned for allegedly breaching court protocol during a previous corporate hearing involving one of his companies. The court's complaint stated that he had disclosed sealed case details at a press event a few weeks prior, a straightforward violation of conduct. Or so it appeared. That morning, Judge Deirdre Colton presided, a stern and meticulous figure renowned for her uncompromising stance, particularly with prominent figures. She glanced up from the bench, locking eyes with Musk for a brief moment before returning to her notes. "Elon Musk," she began, her tone steady yet authoritative, "You have been found guilty of violating federal court orders concerning sealed testimony. The fine is $3.2 million, due within 14 days. There was no gasp, no dramatic pause. This was, after all, Elon Musk, billionaire, CEO, media lightning rod. A few $1 million wouldn't rattle him. Yet something about his posture, standing there with his hands loosely clasped, showing neither reaction nor protest, caused a subtle shift in the courtroom's atmosphere. Judge Colton leaned forward slightly, perhaps anticipating a response. "Do you understand the terms of the ruling?" she inquired. "Yes," Musk replied quietly, "but I'd like to address the court." Here was a specific case, a ruling, a precedent with a date. It wasn't a flamboyant gesture or a theatrical display, it was a strategic, calm, and precise response. Everyone in that room now realized it. But Judge Colton didn't appreciate surprises in her courtroom, and Elon Musk had just flipped the script. Judge Colton didn't respond immediately. She sat with her fingertips pressed together, staring at the man who had just cited circuit law as if he were at a boardroom table. For a long moment, the only sounds in the courtroom were the hum of the overhead lights and the occasional clack of a reporter's laptop keys. "Elon," she finally said, dropping formalities for the first time, "you understand that citing a precedent in this courtroom doesn't guarantee dismissal. This isn't a theoretical argument, it's a federal penalty." Musk didn't flinch. "I understand, but it's not theoretical if the penalty itself ignores its own framework." It wasn't just what he said, it was how he said it, composed, measured, as if he'd rehearsed the lines 100 times, not in front of a mirror, but from a place of deep conviction, not arrogance, not charm, but clarity. The courtroom's atmosphere shifted. Judge Colton was no longer addressing a man accused of misconduct, she was debating someone who might actually know what he was talking about. A reporter in the back whispered, "Why didn't he bring his legal team?" Another leaned in. He probably wanted to make it personal. And perhaps he had, because by this point, it was personal. "Mr. Musk," Colton said, reverting to a formal tone, "are you requesting a formal motion to dismiss the fine?" "No, Your Honor, I'm requesting a review of the ruling under Section 1287F, Clause 4. I believe the court's fine exceeds what the statute permits in cases where sealed disclosure isn't specific and is intended to address imminent shareholder concerns." He paused. "And I can provide examples of rulings that support this reasoning." Judge Colton exhaled, "You're serious?" "I wouldn't be standing here if I weren't." There was something slightly offbeat about it, but not disrespectful, just unusual, like watching someone recite the rules of a game they weren't expected to understand, let alone win. She instructed the clerk to retrieve the transcript of the March 11 hearing and to have the full ruling from Stanfield v. U.S. Tech Holdings on her desk by the end of the day. The clerk stood and disappeared down the hallway, leaving the room in sudden silence. "Elon," she repeated, this time like a parent trying to grasp a child's logic, "you understand what's at stake. You're not just questioning integrity, you're questioning the boundaries of judicial discretion." He nodded. "Yes. But with all due respect, Your Honor, if a court can impose unlimited fines for statements not protected by the actual wording of a gag order, then where does that discretion end?" A man from the Securities and Exchange Commission, seated behind Musk, scribbled something in a legal pad. Another lawyer from a rival firm discreetly pulled out his phone and began typing under the table. This was no longer a simple contempt hearing, it had become something else, a moment, a turning point. A moment law students would write about years later, when a defendant chose not to fight the charge with lawyers or theatrics, but with logic. Musk stepped to the side table, picked up a printed copy of the March 11th order, apparently one he'd brought himself, and handed it to the judge. "Pages 3 and 4, he said, "third paragraph, you'll see the exemption clause." Colton didn't look up as she took the paper, her eyes scanning the page quickly, her lips pressed into a line. "This court has discretionary authority," she stated. "But even discretion," Musk countered, "has limits." No one spoke. Then she slowly raised her eyes, not with anger, not even with irritation, but with something akin to realization. She didn't dismiss the fine, not yet. But something in her expression suggested the certainty behind it had cracked. If Elon had punched a hole in the dam, the real test was still ahead. How far would the water flow? By the time the courtroom reconvened after the lunch break, snippets of Musk's self-representation had already spread across the Twitter feeds of local journalists. National media outlets began to take notice. The hallway outside courtroom 7B filled with camera crews, legal analysts, and onlookers who had never cared about procedural statutes but were now wondering if Elon might actually win this case. Inside, the atmosphere was quieter but charged with an odd tension, as if everyone was holding their breath, waiting for a misstep, a stumble, something to prove he was just another tech mogul playing lawyer in a courtroom. But Musk didn't falter. He sat at the same table, hands folded, his face a blank slate. He didn't check his phone or glance around, he simply waited. Judge Colton returned, holding a yellow legal pad covered in notes. She didn't sit immediately. "I've reread Stanfield twice," she announced, "and reviewed subsection 35B of the gag order. You were correct about the exemption clause." A faint rustle swept through the gallery, but she held up the copy Musk had given her. "However, that exemption applies only when disclosure addresses direct consumer safety threats, not speculation. Your statements at that press event spoke of a potential risk, not a confirmed one." Musk nodded. "Fair. But the language doesn't require confirmation, it requires good faith, which is a legal standard. And a court cannot penalize good faith disclosure that falls within those parameters, even if the concerns later prove non-fatal or exaggerated." She stared at him. "You're walking a tightrope, Mr. Musk." "I've walked tighter," he replied. A few chuckles echoed from the back row. Even Judge Colton permitted herself a faint smile, but only for a moment. "I also reviewed your timeline," she continued, settling onto the bench. "You made your comments 2 hours after the hearing. That timing suggests you may have spoken before receiving the full written ruling. Are you claiming you didn't have access to the language?" Musk shook his head. "No, I had access. But the oral summary of the hearing was vague. The clerk sent the full transcript via email 6 hours later. By then, the press already had my statement." Silence settled over the courtroom again. Judge Colton leaned forward. "So you're telling this court you take responsibility for the timing, but not the intent?" "Exactly. I was trying to warn shareholders about a pattern I believed could pose a long-term risk. It wasn't about ego or headlines. And the data I referenced wasn't from sealed documents, it came from our own internal audits, which makes it mine." A young lawyer in the gallery whispered to her colleague, "He's pulling every thread." Her colleague whispered back, "And somehow, it's holding." Colton flipped through her notes again, then looked up. "You know," she said, "this court isn't accustomed to being corrected by civilians." Musk responded without hesitation. "Then perhaps that custom needs re-evaluation." It was bold, direct, but not smug. The tone wasn't that of someone trying to win an argument, it was the tone of someone who believed truth mattered more than who delivered it. For a few seconds, the courtroom didn't freeze, it simply paused, as if everyone was slightly off balance but unwilling to admit it. The judge spoke again, more slowly this time. "You're forcing this court to consider a precedent that hasn't been applied in over a decade." "I'm only asking the court to apply its own rules," he said. Colton tapped her pen on the desk, once, twice. "I'll take this under advisement. We'll reconvene in 24 hours for a final ruling. Until then, no further statements to the media." "Understood." "Understood." She stood, gathered her files, and exited without another word. Musk lingered at the table for a moment, then calmly collected his papers and left the room, not as someone who had won, not as someone who had lost, but as someone who had said what he needed to say. But as he stepped into the hallway and faced a wall of waiting reporters, it became clear, this was no longer just a courtroom moment, it was about to become a national conversation. The next morning, the gallery was packed before the doors even opened. Reporters arrived 2 hours early, clutching microphones and power cords like weapons, scanning the parking lot for the man at the center of it all. Some had driven from neighboring cities just to witness the proceedings. Not a single seat remained empty. Even Judge Colton's bailiff had to remind spectators that this was a federal hearing, not a movie. Yet it was hard to shake the feeling that something extraordinary was unfolding. Musk entered quietly again, dressed almost identically to the day before. The same suit, the same expression, but something about his presence had shifted. He was no longer just a billionaire, he was the man who had walked into a courtroom and, through logic and restraint, made a federal judge think twice. The prosecution table, which had held one lawyer the previous day, had multiplied overnight. Now there were three, two from the original team and a new face from the special counsel's office. That alone spoke volumes. At 10:02, Judge Colton entered and called the room to order. "I've reviewed the materials presented yesterday," she began, "and consulted with a panel of circuit counsel. This ruling carries significant weight. Judges didn't do this unless something deeply inconvenient had surfaced. Elon Musk's actions," she continued, "did indeed violate the spirit of courtroom protocol, particularly regarding confidentiality. However, the penalty initially imposed may have exceeded the authority granted by the framework outlined in Section 35B. A pause lingered as Judge Colton glanced at Musk. "Your interpretation of the exemption clause, along with your reference to Stanfield, was accurate. And while this court isn't in the habit of casually overturning its own penalties, the fine will be reduced from $3.2 million to a symbolic $25,000, acknowledging both the violation and the legal argument that mitigated it." No one clapped, but a wave of astonishment rippled through the room. Elon didn't smile or nod, he simply said, quietly, "Thank you, Your Honor." The judge wasn't finished. "Let me be clear," she continued. "This court isn't granting you a pass because of your wealth or public status. You earned this review because you came prepared, respectful, and precise. That's rare, and it matters." A woman seated behind Musk leaned toward a man and whispered, "I thought he'd be arrogant, but he's not. He's just, different." Judge Colton closed her folder. Court is adjourned. People rose to their feet. Reporters rushed toward the exit to file their stories. Musk lingered at his spot for a moment, watching the judge depart. Then he turned, walked past the silent gallery, and exited through the same doors he'd entered. But beyond those walls, the world was already crafting its version of the story. Headlines began appearing within minutes: "Elon Musk challenges court fine and emerges victorious." "Judge revises ruling after Musk's self-defense shakes the courtroom." One man, no lawyers, and a stack of precedent law. Analysts started debating, was this legal brilliance, or just another example of the wealthy playing by different rules? Did he prove courts can be swayed if you're influential enough, or that truth can still challenge even the most rigid systems? Some argued Elon Musk had orchestrated it all for public sympathy, staging a performance. Others believed the opposite, that he was fully prepared to lose and spoke because he felt it was right. But one thing was undeniable: everyone witnessed it. Not in a headline or a tweet, but in real time, a man stood in a courtroom, challenged the very structure trying to penalize him, and changed its mind, not with money or power, but with words. Yet as the noise outside grew louder, the real storm hadn't even begun. The public now had questions the system wasn't ready to answer. That same day, Judge Deirdre Colton sat in her chambers with a cold cup of coffee and a notepad filled with notes she never expected to write. Her clerk had stepped out. Her phone buzzed with missed calls from legal colleagues and journalists she hadn't spoken to in years. She stared at the door for a long moment before turning back to her notepad. There, in her own handwriting, were 5 underlined words: "He wasn't wrong, not entirely." Colton was no stranger to controversy. In her 26 years on the bench, she had presided over racketeering cases, class action lawsuits against pharmaceutical giants, and civil rights disputes that drew national attention. But she had never encountered someone like Musk, someone who walked into a courtroom, spoke plainly, and overturned a multimillion-dollar fine using only footnotes and federal precedent. What unsettled her wasn't that she had to reduce the fine, it was that he'd forced her to acknowledge the court might have overstepped. She picked up the order again. Section 35B, the exemption clause, the whistleblower intent, it was all there, clear and unambiguous, buried on the 4th page, exactly where he said it would be. She scribbled a note in the margin, "Did we miss this?" Why? A knock at the door interrupted her thoughts. Her clerk returned, holding a thin folder. "Judge," he said, "the Legal Oversight Office called. They want a report on the Musk adjustment by Friday. And Channel 12 is requesting a statement." She waved off the second part immediately. "No press." He hesitated. "That's not all. Law students at UC Davis are circulating the transcript. Professors are assigning it for legal ethics discussions. It's turning into an issue." She raised an eyebrow. "An issue?" He nodded uncertainly. "They're calling it the Fresno defense, when a defendant flips the courtroom using the system's own tools." Colton nearly laughed but held back. "Close the door," she said quietly. Once the door shut, she turned to her screen, where the raw transcript of the previous day's session was displayed. Elon's words, calm, logical, strategically placed, stood out like highlighted lines in a textbook. This concludes our narrative journey. I trust you found this gripping saga of intrigue, cutting-edge innovation, and astonishing discoveries captivating. From where are you tuning in today? I'm curious to learn which corner of the globe this tale has touched. If this escapade held your interest, please give this video a thumbs up and consider subscribing to the channel for a steady stream of compelling, mind-expanding stories just like this one. Fresh material is posted frequently, ensuring you're always in the loop for the newest spellbinding adventures. Be sure to pass this video along to your loved ones and friends. It's a great way to share positivity and insight while expanding our circle of story enthusiasts. Your encouragement is invaluable. Thank you for joining me, and I look forward to welcoming you back for the next tale.